Hey, good afternoon. This is Steve Wilkes at the Wagner Law Group. On behalf of my colleagues and myself, welcome to our webinar on service agreements. I think that service agreements are very common. You know, every plan, every provider has them or should have them. They appear in different formats, and we're going to talk today about maybe just a couple of things that we've seen in terms of drafting agreements, between plans and advisors or TPAs and non-fiduciary broker-dealer firms, for example, that are of interest, and hopefully will be provoking for you and how you're handling your agreements currently. So I think that I'll have some general comments on what the law requires, maybe in general, about service agreements, and we'll focus in a little bit on some of the provisions, like about services and compensation, indemnification, assignment of services, to another party, or using, subcontractors. A few of the other general provisions that we tend to see in these agreements, and then try to wrap it up, and as always, try to honor our 30-minute commitment in terms of helping you stay on schedule for your day and not run over that. Let me also just point out that I am sitting in our California office here in San Francisco. We've had a little bit of technical difficulty in our building today. It seems to be impacting a variety of offices, not just ours. So if by chance the sound goes out or I lose you, we had a few technical failures once or twice today. I apologize in advance. If that happens, we will get back to you and reschedule this webinar. So thanks for your understanding in that regard. So we're going to talk about these service agreements with plans, and I think that, first of all, let me say that this presupposes that the whole process of identifying and vetting the service provider is already selected. That's a whole webinar in and of itself, and I know many of you are familiar with that process. That the duty to really have the right criteria in place and pick the right provider. But after you've done that, after you have the right person, then what? How do you basically form a contract? Because that's what it is. Our service agreements are contracts, legal contracts with terms and conditions that we want to have. And I think also it's good to think about these agreements not only as legal contracts, but the way we try to think about them at our firm anyway is that it's a legal contract with terms and conditions. It's a risk management tool. It can serve as a compliance tool for various disclosure agreements. But it's also reflective of a business relationship that you have with your provider, or that the provider has with your client. And in that sense, it's sort of it can be kind of a marketing document as well. So we try to approach them in terms of being very user-friendly, if you will, and to really try to serve the best interest of all the parties. Now, what does ERISA require about these service agreements? Unlike the Advisors Act, which has a few provisions, sections baked into the Advisors Act about written requirements, or maybe some specifications under the FINRA rules or the Exchange Act that would apply to broker-dealers. There's really nothing, in ERISA per se that talks about or sets any specific requirements for these service contracts. But but we can pick out two. We can deduce two. And I would say that the law requires, one, that the agreement be reasonable in the sense that it's fair and fairly negotiated and at arm's length and not extreme or extravagant. So there's a reasonable standard there. Then there's also the reasonable requirement that's part of 408B2. So in a way, many people are using these agreements as the disclosure document for 408B2 purposes. So I think those are think about reasonable in the agreement, through two lenses: the general, common, everyday, ordinary meaning of the word, and specifically as what reasonable means in terms of 408B2. I think a good agreement, in addition to having all the the legal bells and whistles and what have you, a good agreement is one that'll really be, really understood by both sides. No ambiguities, no gaps. It should be in writing. The process of preparing your agreement, should involve some sort of benchmarking. You should have some sense of how the terms and conditions look against those that are negotiated with other plans of similar size or other providers of, similar ilk, if you will. It should be reviewed periodically. Blessed by legal counsel. Usually helps to get a little sign off from your counsel on the agreements. And I think they should be negotiated, obviously, at arm's length. I want to emphasize the word negotiate because I think that we're at a point now where we're seeing a lot of our agreements are fortunately very they're very accepted by both parties, which is a good thing. People tend, I trust my advisor, I'll take their paperwork. We work with this plan, we'll just take their basic representations without a lot of dialogue. But I think, the old saying, good fences make for good neighbors. These agreements are looked at, to clarify ambiguities or to help people establish their positions in times of trouble, which unfortunately happen once in a while. So I think the agreement is the time to, if you have a stake that you want to put in the ground in terms of getting a particular position on something or a particular term or condition in place, negotiating the agreement, is a process that allows you to get that in place. But I also say that, we like these agreements to be, pretty fair and even-handed. When we work with a client on an agreement, our legal duty, our responsibility is to represent the interests of that client. But I think we always advise our clients that the best agreements are the ones that are, pretty fair and even-handed and don't try to really sneak anything by the boards or gain any particular, fancy advantage buried in the boilerplate somewhere. That the best agreements are ones that are, fair to both parties. What does all that mean? It means at the end of the day that a good agreement is one that could be read by both parties, and you know who is doing what, when they're going to do it, how they're going to do it, how long that period of time or service period is during which the agreement is in place, and how much it's going to cost. I mean, those are pretty much the basic questions, and we like to see agreements that answer those questions. Usually in our agreements, for those of you on the line that we have drafted agreements for, and it's fairly common, usually it's one of the very first sections in our agreements, if not the first section, is one that will describe the services. We might map it out in that section, or we might like to attach an appendix, for a schedule of services. But I think it's really important that, the service provider, and the plan, agree on the very, very specific scope of services that are going to be provided and the fees that are going to be charged, before those services start. A lot of times you see pretty elaborate schedules come in from, record keepers or TPAs as to all the different things that they're doing. We really like to emphasize that we'd like to see a really clear break between fiduciary and non-fiduciary services. We think that's really important, or how they're allocated among different parties. And we like to see not only what you're doing, but what you're not doing. Right? By that I mean, an affirmative and a negative provision. Here's what we're doing, and by the way, just to be clear, here are the things that we are not responsible for. And I think sometimes people back up on that and they say, well, that's almost like an anti-marketing statement. I don't want to tell my client what I'm not doing for them. But I think it just makes good understanding and sets expectations properly. That's what all the parties are doing. So that's the way we like to draft ours. For example, we might talk about providing an investment function with regard to certain account assets, but we'll be clear in our agreements that investment function does not include certain types of assets. We might carve out employer securities, real estate, unless it's part of a REIT or in a real estate fund. You want to be very careful about whether or not you're touching self-directed brokerage accounts or brokerage windows. You want to be careful as to whether or not you're dealing with the question of participant loans, whether they're appropriate or not for the policy, whether or not you're willing to work with illiquid assets or other assets that are hard to value. When you're talking about establishing qualified default investment alternatives as a provider, you want to make sure that you specify that you might be structuring or working on a fund that meets the requirements of a balanced fund, for example, but there are still other parts of a QDIA, such as employer notices that have to be given to participants, which you may not be responsible for. And if that's so, you need to carve it out. Otherwise, a plan sponsor might think that the whole ball of wax is residing with the investment provider on that QDIA. So it's really important to carve out all the do's and don'ts and put some limitations on those functions. And typically, we'll see things like also by the, we're not the plan trustee, we're not the custodian, we're not the administrator. We're responsible for selecting investment options, but it's from among a universe of options that the plan sponsor has already selected. Just back and forth, just to be really precise about it. One that I've been talking about more recently with clients, though we've been talking about it for a couple of years, is getting into the whole notion of class shares. Plans. If you're on a platform where there are multiple classes available, and we've all seen some of the litigation around class shares and the different expenses that go with that. Who's responsible for choosing different class shares? And similarly, if one share pays 12B1 fees or something that might be used to pay for the plan, are you supposed to be looking for those, or does a plan sponsor want those selected so that there's another source of revenue available to pay for the plan itself? These are the kind of things that you really want to see fleshed out in the service schedule. I think it's also important to have a little bit of discussion about the process underlying the service. It's one thing to say we'll create 5 risk-based portfolios. It's another thing to say we'll create 5 risk-based portfolios comprised of mutual funds. It's another thing to say we'll construct risk-based portfolios that are constructed out of mutual funds and ETFs. It's another thing to say we will do that, but it's open architecture. It's beyond the investment options that are selected for the plan menu itself. So sometimes we try to draft these very carefully and get the process involved as to what how far you reach in terms of constructing funds. But it's very important to have the process in place. I think also the process for adding or changing these services, or for changing anything, for changing fees. Typically you'll see a requirement that says any change or modification to an agreement has to be in writing. But for those of you who are familiar with the old, I think it was the Aetna letter from the DOL. In effect, you can have a negative consent provision. Maybe it's administratively beneficial to both parties to have a provision in place that says either party could make a change to the agreement in terms of a fee or some criteria or what have you. And as long as the other party does not object within 30 days or 60 days, it's deemed to be a consent. I think so. It's nice to spell out that, have that, and consider that in your agreements. Finally, I think also one thing that we're seeing coming up now a little more frequently are the participant disclosures under 404A5. I mean that's the service provider has the responsibility in the 408B2. It's really at the plan administrator level that you get the plan sponsor level that you're getting the 404A5. But in the real world, most plan sponsors aren't able to pull that information together themselves. They're looking to their record keeper to pull it off the platform, or they're looking to their investment advisor or their consultant to tell them how to do it. And I think it's it's really important to be careful as to identify who is going to provide the information, create that data, and who owns the legal responsibility. I mean, you could have a firm help provide the data, but not necessarily want to own it in full, as the liable party for providing it. So participant disclosures are an area of services that we're seeing a little more conversation around these days. As I said before, I think separating out the fiduciary or non-fiduciary piece is really important. We've been doing it for a long time typically on separate schedules, or else we'll mark very clearly in our agreement. It'll be very clear which services are fiduciary and which aren't. And I think given the way that the services are evolving in the marketplace, it's very important to distinguish between what I use here, 321, which I mean, in the kind of the street sense, non-discretionary advisor. 338 meaning discretionary manager, investment manager, and 316 meaning stepping up and really owning the fiduciary responsibilities of the administrator. Sometimes this stuff doesn't quite get allocated properly or identified properly, or it's not assigned properly. Just the process, just making sure that you have a good representation that the appointment of your 338 manager was done in accordance with ERISA. So there's a lot of detail that fills in behind these allocation of fiduciary titles that we'd like to see spelled out in the agreement if possible. It's nice to know sometimes to identify co-fiduciaries. Sometimes some people like to have almost like an account, like a brokerage form account section on the agreement, even if you're doing it from an investment advisory platform, where you're actually going to name your you're going to name the custodian, the trustee, the account, where the accounts are held, almost like filling in an account opening form. Some people like to identify the other parties that are involved with the plan on the agreement. That's an option to think about. We don't see that all that often. That's a little bit of a carryover, I think, from brokerage account opening kind of provisions. The reason that the fiduciary stuff, one of the reasons I should say that the fiduciary or non-fiduciary stuff is important is that in addition, you want to allocate the proper standard of care for each category of service. Obviously, if you're operating in non-fiduciary capacity, the way the law would play out is that you'd be subject to negligence or gross negligence standards, perhaps, as compared to the fiduciary reach of ERISA. So those are things that you want to try to specify clearly in the agreement. And also, by implication, when you have a fiduciary involved, it kind of begs the question about whether or not there's fiduciary insurance. Do you want to get it, if you're a plan sponsor, do you want to get a representation from your advisor that it maintains fiduciary insurance? Do you want to get a representation from your discretionary fiduciary, your 338 manager, that it has a bond? Or are you going to allow that manager to latch on to the bond which the plan sponsor is likely maintaining? By bond, I mean the bond that's required for handling funds. That's separate and distinct from insurance. So there's a lot of things that fall out from the fiduciary categorization that we think are important. I think the next big one that we get to in our agreements obviously involves compensation. Pretty standard contractual term, right? You talk about how much you're going to pay, who you're going to pay it to, when are you paid, what's the form of payment, so on and so forth. I think that the compensation as it is important as a contractual term, just as a business term in the agreement, and obviously to the extent that these agreements are serving a 408B2 purpose, it becomes a very important disclosure item. So you want to make sure that you're covering all, direct and indirect compensation, the manner of payment. Sometimes we see people getting into late payment provisions, a little interest charge. We hear both sides of the coin. Some people don't want to put it in there. They view it as an anti-mark and they're afraid of, ruffling their clients' feathers. Other people will put it in, but they don't necessarily want to enforce it. I think that's kind of just a business judgment, depending on the kind of relationship and how you're running the, kind of the payment part of your service platform. But it's something that you might want to think about or discuss a little more. And of course, there's always the overlay of just having a reasonable standard. So remember, these ERISA agreements, compensation needs to be reasonable for a couple of different issues. And sometimes you see some other little issues out there. These tend to be a little more sophisticated, but you might get into, there might be some things out there in terms of 12B1, revenue sharing, 12B1 fees, sub-transfer fees, those kind of things that need to be clarified and discussed how they're used. Maybe there's a float issue involved, and those are the kind of things that you want to see dealt with in the compensation section as well. Indemnification, we have it in, I would say we have it in the vast majority of our agreements, but I want to say that the whole concept of limitation of liability and indemnification, they're really pretty significant. And sometimes we just see parties accepting kind of the standard paperwork, if you will, and other times we see it very heavily negotiated. So I think that if you step back and think about these agreements a little more, I think the first question is, should there be indemnification? Well, it's not a requirement. We have a few agreements where there is no indemnification at all. I mean, people just decide that they just don't want to have it in there. If one party or the other does something wrong, they will pursue a legal remedy or arbitrate it or try to resolve it. But there's no indemnification per se. I mean, clearly one of the big advantages of indemnification is that you typically will get your legal fees covered. So it's one thing to be right. It's another thing to be out of pocket a lot of money to prove that you're right in the courthouse. So indemnification is important, clearly in that sense. Then you get to the next level. If you decide to have it, is it one way? We see a lot of agreements are presented where, one party proposes to be indemnified by the other, but it's not mutual. And again, that's kind of a judgment call, a business call as to, how you want to conduct the business, what you think you can, get away with, if you will, if it could be one way in your favor, but not the other. At the end of the day, we typically advise our clients just to be even-handed and fair, mutual indemnification, fair to both parties. That seems to work. If a client were to say to me, no, we want to negotiate for every advantage we get, we want to be indemnified, but we don't want to indemnify the other party if we don't have to, then obviously that would be that's what we would ultimately do if that's how the client wanted to approach it. But, these indemnification provisions can be drafted. You can take one tact and they can be drafted very strongly in favor of a plan sponsor, or they could be drafted very strongly in favor in favor of the service provider. So there are just some different approaches that can be taken there, and some different things to think about, I suppose. One thing that sometimes gets forgotten in terms of the indemnification is just remembering that we do have some general rules under ERISA about the limitation on what you can or can't do to indemnify or protect fiduciaries. So I think that's something that needs to be checked carefully. And I like to remind our clients that we want to make sure, it's always nice to map it against the E&O or fiduciary liability provisions that might be carried by that part, just to make sure that the terms of the agreement and the terms of the insurance policies are congruent and don't conflict with each other in any way. So typically that's what we see, and we'll have in these agreements, we'll have some basic language about we're not waiving any rights of the parties or fiduciary liability, and we generally have some sort of a limitation of liability provision, which really just states what the law is anyway. Even if you don't have it in there, the law is what it is. So you're going to have those limits are going to be in place. There we go. Sorry, guys, that's my first example of. I'm going to blame that on the internet, but that might have been my finger too heavily on the on the key, changing the screen. I think what we're seeing now in this world, another thing to think about is just changing parties, changing dance partners, who's providing services. I think when you're doing these agreements, it's really important to know whether you're dealing just with one party, whether there is an affiliate that's involved or a subcontractor. How is that mapped out in the agreement? Who is primarily liable in the event that one of these affiliates or subcontractors fails to perform or commits an error? So I think those are things that are part of the negotiation process when you're working on the agreement, to identify who all the parties are. You might have a sale. Your advisor, your accounting firm, your TPA might be sold. What happens then? What kind of notice do you get? Who's liable? How do you get access to the records? Who owns the records? Does TPA own those files, or does the customer own the files? Those are the kind of things that should be thought through a little bit in these agreements. Who owns the all the plan data? How do you get it? Typically, in the event there's a sale or a termination, you want to make sure that you have a smooth handoff. At the end of it's all about working in the best interest of these plans. That's good business sense, and that's what ERISA wants us to do. So you want to have provisions that allow for smooth integrated handoff to a successor party, or to allow for reasonable transition period, good notice period for a change. How are you paid during that period? Does the liability still run through that period for the service you're providing? Is still paid? Those are the kind of things that need to be spelled out clearly. Do you have an automatic renewal, or should it be renegotiated every year or 3 years? How long should the renewal period be? Should these agreements be evergreen? Should they run for 2 years, 1 year? A lot of times, these agreements are coming through, and there's not always a lot of discussion about this, but we're seeing now, we certainly encourage people to think about it, not just take, the boilerplate terms, and to think about how it best serves their needs and how they can best, work with the provider or with the client, on these conditions. There's so much other stuff going on in these agreements. We're seeing, obviously, there's a lot of plan data that's in there, and if you're a service provider, you want to know that whatever you get from your client is accurate without independent verification. That seems to be a fair statement. Or if you're the plan and your service provider is telling you that they're providing on third-party data, Wall Street Journal, Morningstar data, whatever that you want to know if it's being vetted, if are they relying on it, what kind of data are they relying on. It's one thing to rely on Morningstar, it's another thing to rely on Steve Wilkes' financial reporting service. That might not be as reputable or as reliable. So I think it's really important to understand that a lot of information sharing is required to make these agreements run, and each party has an interest in knowing, where the data is coming from and how accurate it is and how they can rely on it. Given the world we're living in right now, we're spending a lot of time thinking about electronic, disclosure, electronic distribution, electronic consent. I like to see good provisions in our agreements for use of email and websites. Just to back up for a second, the law is still a little bit unorganized here. The SEC, has kind of upgraded. They've put out a few releases over the years, for the advisor, broker-dealer community. We have some guidance from the Department of Labor. We clearly know that it's okay to, to use electronic communication for certain things like transmitting an SPD, participant statements, 404A5, but there's really not all tied together in one beautiful package yet. So a little bit of uncertainty there, but I like to have these a good consent in the agreements for the use of email or website. And you need to think about it in two directions. Number one, the service provider. Do you need or want your client to allow you to provide routine communications or regulatory notices by email or posted on a website? If so, what's the email? What's the website? If that's going to change, whose responsibility is it to let you know that it's changing? And similarly, if you are willing to accept communication from a client, on email as compared to, a FedEx or UPS letter or something just posted in the mailbox, is that okay with you? Is there an official email designated for incoming client communications? So when we draft these agreements now, we put up these consents, if you will, in bold, and we think it's really important that they're understood and that there's a good process in place for keeping the email address updated. There's a lot going on. I think, generally you'll see standard provisions about confidentiality, but I think the way that lays into the privacy rules, you have a lot of account data going back and forth, account numbers, personal information. Occasionally, participants have, social security numbers that are going back and forth. That all needs to be done in compliance with other laws governing the, I'll just call them privacy laws. And so you want to have good provisions about encryption and how that's being handled. You want a representation that any data you're providing to a service provider will be stored properly in compliance with the privacy laws, so on and so forth. But that's an area that I think probably needs a little bit of work in some of our agreements, given the way we're transmitting stuff back and forth these days. Generally speaking, dispute resolution, I think I think from the securities industry, we have kind of a built-in default that everyone's going to arbitrate, which is fine. We have arbitration in a lot of our agreements. but we see some different provisions. Some people have no dispute resolution at all. That's a pretty small number. They just assume that if something goes wrong, they have the ability to pick up the phone or have a cup of coffee or go to a meeting and work something out with the client. Some people like to lay out more of a roadmap. They'll put down as a mandatory step mediation first. Good faith effort to mediate something, which is a little less formal process than arbitration. I think the thing, obviously I think the general thinking is that if you have a formal mediation or arbitration process, you'll have a successful outcome at some point, and anything is better than paying the lawyers to be in court on litigation. And I think on litigation it can be very expensive. I think what I've seen over the years is that there's some advantages and disadvantages. If you're in a fairly complex plan, or you feel there's a lot of money at stake, or the issues are fairly technical, I think that one advantage that you might get by being in the courthouse is that it's just likely, given the way our courts, our federal court system is structured, it's likely that you'll get a district court judge. He or she is of, hopefully of a good level of intelligence. They have a couple of clerks. They have access to resources. I think the ability to kind of digest and analyze, ERISA issues, it's probably more robust in the courthouse than it is at the typical mediation or arbitration, where the default position is to cut everything in half and send everyone home. I'm not sure that the ERISA issues, which we all know can be kind of complicated and a little funky every now and then, I'm not sure that they're always fully digested or properly understood at the mediation or arbitration table. Nonetheless, it's a less expensive alternative, and not every dispute is going to involve really technical ERISA issues. So that's something just to think about a little bit when we're drafting these agreements and setting up our dispute resolution. Governing law, obviously ERISA preempts. I just want to say that there are some other laws that we need to think about in these agreements. There's an Investment Advisor Act overlay, perhaps. There could be a FINRA overlay for broker-dealers, or the Exchange Act. There could be state insurance regulation, depending on the kind of product that's sold through the insurance company. And even getting down just to basic contract terms. There are some states that have a couple of funky provisions on the books when it comes to arbitration, for example. So I think it's really important that we always remember to take a look at these agreements in light of any state laws that could be a little bit unusual for some of the less frequently discussed provisions of our agreement. We try to highlight those for our clients as well. Sometimes these agreements, you could argue, if you're creating risk management portfolios, or you're creating intellectual property, who owns it? We're starting to see a request by some people to put some privacy or put some limits on the intellectual property, if you will, that's created in some of these agreements in terms of investment strategies, or even just methodologies for processing quadros or 401k loans, or just maybe this industry knowledge that comes out of a relationship between a service provider and a plan in a specific industry. So we're starting to see some interest in just kind of putting a limit around the IP that's created. And finally, I think that we all know about ERISA spending accounts, and we're starting to see and recommend that maybe we have a little more discussion about those accounts, in the agreements themselves, that we acknowledge that they're there. Can hold funds in a certain way, be used for certain purposes. Who owns the spending account? Is the ERISA spending account one in effect as part of the plan, or is it back at the corporate level, or back at the record keeper? I think it depends on the nature of that particular revenue sharing arrangement, but probably paying a little more attention going forward to these spending accounts would be a good thing to do. So we're just over 30 minutes here. What can I say? These are legal documents that have legal terms and conditions. We think they should be straightforward, even-handed, fair to both parties, helpful and beneficial to both parties. The plan sponsor should be able to pick up an agreement and say, "Wow, I'm really impressed. I'm getting this great bundle of services. I really understand what my provider is doing for me and know how much I'm paying them. I'm really happy." So these agreements serve a lot of purposes. They should be a roadmap to all those key things. What's being done, who's doing it, how is it getting done, when, what's it going to cost, it's also it's a good measuring stick for evaluating a service provider down the road. You should be able to pick up your service agreement and go back a year later and just check through the schedules and provisions and see if everything is being delivered. And obviously, we want all the service agreements, whether it's with an advisor, TPA, your accounting firm for an audit. We want those agreements to reflect, kind of the best practices and forward thinking in the industry. So I'm glad. If any of you have any questions, you can always shoot them in on email, or you feel free to email me directly or give me a call. I'm always glad to talk with anyone for, a little bit, answer a quick question, give you a little perspective on anything happening with your service agreements, with your clients or your providers. So please don't hesitate to do that. And on that note, I will say thank you very much on behalf of the Wagner Law Group for listening in today. I hope this was helpful to you. Our next webinar is going to be toward the latter part of June, and we're going to be talking about a different aspect of our employee benefits practice. I'm going to be talking about deferred compensation agreements, and specifically we're going to take a look at how insurance is used to fund those agreements. Thank you very much. We'll talk to you next time.